The employment permit system in Ireland is administered by the Department of Enterprise, Trade and Employment. Immigration control, on the other hand, is supervised by the Department of Justice through the Immigration Service Delivery Body, that's ISD. Therefore, obtaining an employment permit does not automatically grant the right to enter the state, but it would usually be the case that an employment permit will lead to a successful application for immigration permission. It is the Minister for Justice, pursuant to the Immigration Act 2004, who is empowered to grant an immigration permission. An employment permit holder must attend ISD to seek an immigration permission on foot of the employment permit. An Irish residence permit, IRP card, is then issued showing the permission that has been granted, the stamp type and the duration of the permission. The person's passport is stamped accordingly, and this constitutes registration of the permission granted. The legal framework in relation to employment permits includes the Employment Permits Act 2003, the Immigration Act 2004, the Employment Permits Act 2006, and various employment permit regulations in 2017, 18, 19, 20, 21, 22 and 23. The Department of Enterprise, Trade and Employment maintains two lists when it comes to employment permits. One is the list of ineligible categories of employment for employment permits. The second list is the highly skilled occupations list. The key rule of the system is the 50-50 rule, which states at the time of an employment permit application, at least 50% of the employees of the Irish business must be EEA or Swiss or UK nationals. This rule can be waived, however, in certain circumstances, and this is known as the labour market needs test. There is also a 12-month rule which states that a new employment permit will not be granted to a foreign national if he or she has not completed 12 months employment with his first employer. There are exceptions to this rule, for example, redundancy. The processing times for employment permit applications are published on the website of the DETE, that's the Department of Employment, Trade and Employment, Enterprise, Trade and Employment. And it's easy to see then when a permit might be issued because it's kept up to date, it's kept live. Types of employment permit. One is the Critical Skills Employment Permit, the CSEP. Some key points about this permit include: one, that it's valid for 2 years. After 21 months, an eligible employee can apply for a Stamp 4 permission, which allows them to work for any employer in Ireland. Family members can join the worker in Ireland. The labour market needs test is not required, and if the salary ranges from €32,000 to €63,999, the job must be on the DET's highly skilled list and the employee must have a relevant third level degree. If the salary exceeds €64,000, any job is eligible, provided it is not on the ineligible list and no academic qualification is required. Secondly, you have the General Employment Permit. This is an initial permit which has no minimum duration. There are no specific education requirements. The initial permit can be extended up to a maximum of 5 years. Family members cannot join the worker until she has completed 1 year of employment, and the labour market needs test is applicable, but there are 3 exceptions. The job is in the highly skilled list, or the salary is over €64,000 per annum, or the job is backed by IDA Ireland or Enterprise Ireland. The standard minimum remuneration package is €30,000. Then you have the Intra-Company Transfer Employment Permit, ICT. This allows companies to transfer senior management and other key employees to transfer into Ireland. All occupations are eligible for an ICT permit, even jobs on the ineligible categories of employment. The maximum time in Ireland is up to 5 years, and there are no education requirements. All family members can join the worker in Ireland. 4. There are other types of employment permit, which include a reactivation employment permit, an internship employment permit, contract for services employment permit, sport and cultural employment permit, exchange agreement employment permit. 5. Authorisations outside the employment permit system. The Atypical Working Scheme, AWS, was launched by the Department of Justice to cover short-term sponsored work in Ireland, which is not covered by the employment permit system. There are unique rules for doctors, nurses, fishermen and certain paid internships. Miscellaneous points then to make in relation to employment permits in Ireland. UK citizens have the right to travel and work in Ireland. Their non-EEA family members should use the pre-clearance system operated by ISD if they are seeking to join their family member in Ireland. There is a discrepancy between the IRP card's 1 year permission as opposed to the employment permit duration of 2 years, which necessitates renewal of the residency permission during the life of the employment permit. Posted workers are workers who are either EU or non-EU nationals but have an employment contract in an EU country and they are being transferred to another EU country. The European Union Posting of Workers Regulations 2016 and 2020 are relevant regulations in Ireland. A Vander Elst permission arises from a 1994 decision of the Court of Justice of the European Union and is a form of authorisation for non-EEA nationals. The implementation of the arrangements to comply with the Court of Justice decision in respect of temporary work assignments up to 12 months in duration. That is the situation in relation to employment permits in Ireland. If you find this video useful, I'd appreciate if you gave it the thumbs up down below. And if you're listening to the podcast, the Irish Law and Small Business Podcast on iTunes or Spotify, you might consider subscribing or following the podcast. Thanks a lot.